Now, the Department of Justice and Constitutional Development, in partnership with the Law Society of South Africa, has launched the National Wills Week campaign in Kabokweni in Mpumalanga. The campaign aims to encourage people to draft wills to assist them in safeguarding their assets and estates after death. Marnus Mostert, who's the franchise principal and certified financial planner at Consult by Momentum, joins us now to discuss this. A very good evening to you. Thank you so much for your time. Perhaps let's start off with the basics. Who qualifies for a will?
Good evening, both yourself as well as your listeners and viewers. So very simple. I think the moment that you own something, and often people think it must be a vehicle or a property, something large, but the moment you own something, whether it's a share portfolio, a money market, whether it's jewelry, whether it's furniture, whenever you own something that can be traded for money, that means exactly if at that point, that's when you need a will.
And what makes National Wills Week so significant? I mean, what is it about this week with the information that's coming out and the encouragement for people to really go in and speak to an attorney and have this will drafted? What makes this week so significant?
Look, the emphasis must be on people drafting a will and having a proper estate plan in place. The last data I looked at was around 20% of South Africans having a valid will, and that's obviously, needless to say, a massive problem. So I think the week is just to sort of raise awareness regarding this problem. And to be honest, I think it's a bit of human nature where maybe the urgency isn't always there. We might want to believe that we're going to live forever, but reality, we know that there's two certainties in life, and that's death and taxes, and both are applicable here. So unfortunately, I think it's a bit of human nature coming into it. And I'd always put a bit of the blame on us as financial advisors as well. I think we all should put an emphasis on making estate planning, wills and trusts, and those type of things the heartbeat of our financial planning practices.
Many South Africans still don't have a valid will. I mean, just looking at the stats, 7 out of 10 adult South Africans die without a valid will. How complicated and time-consuming is the administration of a deceased state if one fails to plan by ensuring that they have a valid will?
Paul, what I can tell you is that it's an absolute mess in most cases. The thing is, you're dealing with so many levels of problems that you're creating for yourself. So just thinking about all the assets, so let's call it the stuff that you own. First of all, if you're not drafting a will, you don't have the privilege or almost the opportunity to say, okay, what must actually happen to this stuff? Must it be sold? Must it be given to somebody? Secondly, who must it go to? So now we think about our loved ones. I'd like to believe that when we do think about the things that we own and the money that we do have, we work very hard for it, that we want the rightful beneficiaries to take over those assets, or then be it the funds. What do I mean by a rightful beneficiary? It might be a spouse that has to now take over the responsibility of the kids, but it might be as simple as the disabled person in your family. Without drafting the will, you do not have the opportunity to sort of guide the person dealing with the estate on where those assets must go. So basically, I always want to say that it's you versus the court. It's your decision to draft a will, and you get to decide and sort of nitpick what must happen. In the absence of a will, basically the court takes over the decisions on what must happen to your stuff, to whom it goes, and then worst of all, I'm sure we'll get to it, if there are minor children involved, there's massive implications when it comes to guardianships and the guardian fund and so on and so forth. So that's quite a massive issue.
Marnus, a lot of South Africans simply procrastinate the process of having a valid will. In terms of your financial advice, when one has to perhaps consider the composition of this will, what advice would you give when it comes to the breakdown and the factors that should come to the forefront as one begins the process of drafting that will?
Look, so I think the first thing that people should sort of admit to themselves or realize from this conversation, these things sound very jargon heavy, it sounds extremely complicated, but when you do sit with an expert, it's much easier. So one thing people need to understand is the relationship between estate planning as well as a will. So just by drafting a will is a fantastic first step to take. Please don't get me wrong. That is absolutely a no-brainer. That's sort of next to feeding your children. That's the move you must actually make. So having a will in place, drafting a will is your first step. Secondly, there are unfortunately some costs, some taxes, things we can't avoid, but we can plan around it to have an efficient estate that's being wrapped up quickly, easily, and exactly on your wishes on paper will be carried out. But that starts with drafting a will, sitting down with a financial professional, be it a lawyer or a certified financial planner, to discuss the needs of not only your beneficiaries, so the loved ones you're leaving behind, your children, but also what you actually, how does your will look after the day you're not here anymore? So it's vital to sit down, and again, we've discussed all these complexities afterwards in the absence of a will. In most cases, it's a 5 to 6 page document that shouldn't take longer than a day or two to discuss and Bob's your uncle.
I would have thought that estate planning is a component of the will. Are you talking about, are these two separate documents that are required? Can estate planning not form part of the will?
So estate planning is not per se a document. So it's more, again, seeking professional advice to say, okay, we understand what assets you have, where the assets must go in the absence of, in the event that there are minors, allocating guardians that's actually going to take care of your minor children. Again, minors can't inherit in South Africa, so it's putting a clause into the testamentary trust to ensure the safeguarding of those funds. So that's really the estate plan. Then it boils down to the other side of the coin, is to say that, okay, we've now sort of got a picture of how your estate looks. Again, we spoke about costs now. So then we do a cost estimation to say this is the estate duty, this is the executive fee, this is the admin cost, XYZ. These are the liabilities we need to settle. And then regarding those, let's call it the money flowing out of the estate for cost and tax purposes, we can now plan to make provision for those costs and fees and taxes, so that ultimately the ones you leave behind benefit more from your estate. And that's where the estate planning component sort of attaches itself to a will.
You've advised people to ensure that they sit down with a certified financial planner, and a lot of what we've heard since emphasizing the importance of National Wills Week, the importance of having a valid will. What would make a will invalid?
Okay, so even from personal experience, what I've come across, so the basics are the will should be in writing. That's more or less the starting point there. Then, in most cases, is where the witnesses come in. So you need to sign as the testatrix or the testator. You need to sign on each and every page of your will, as well as the last page where the text ends. And then as well as 2 witnesses over the age of 14. But the catch is these people can in no way, shape or form inherit. So ideally, this should not be family members. Ask a neighbor, ask a friend or something like that, because that's where most people really get themselves into trouble. So the moment that somebody that's eligible to inherit actually signs as a witness, they unfortunately cannot actually inherit from the estate. So that's a bit of a jam. Then naturally you should nominate an executor. You should ensure that what you're doing in the will is legally enforceable. It's not overcomplicated. And then very, very important, the Master of the High Court only looks at the original signed on will, so the original ink on the paper. So it means that original will, please do give that back to the attorney or the certified financial planner, because that original will now needs to go into safekeeping. Please do not keep it in your bedside cupboard. Your house could burn down, then that original will is as good as gone. So my advice in that case is to keep 2 or 3 copies, give it to somebody else, a copy and then the original comes back and for safeguarding and safekeeping purposes. But most of the mistakes are around the witnesses, as well as some people tend to want to overcomplicate what needs to happen afterwards.
Very well. Thank you so much for speaking to us this evening. Marnus Mostert, who's a franchise principal and certified financial planner at Consult by Momentum, expanding on the conversation around National Wills Week.